Thank you all for being here. I'm just going to jump right in. We only have 20 minutes. Bojana, I wanted to start with you, and I'd just like to ask you about the fact that there is a patchwork of global private, or of different data privacy rules across the globe. Do you see that as a positive thing or a negative thing? And would you like to see more countries try to harmonize those in a better way?
Right. So first of all, hello everybody. Good afternoon from London. I think it's morning there. Thank you for inviting me. Sorry, I can't be there live. Look, I mean, we would all like to see more harmonization and more convergence, right? But that may not be realistic at this time, right? We see there are differences in the way we regulate. There are gaps in the way we regulate, but we do want to work together to, as much as possible, look for similar rules and, very importantly, similar or same interpretation of these rules as well. And so I think the best world is probably interoperability, Morgan, right? That's what we are really looking for. We can't maybe have the same rules, but we want to make sure that it's a little bit like those plugs, right? Across Atlantic and with Asia, etc., that we actually work together because we all have got the same outcomes, even though we don't have the same rules together.
Mm-hmm. And Alex, I wanted to ask you about your role. What's the biggest challenge that you've faced so far in implementing the US-EU Privacy Shield, in the last several months?
Yeah, so I mean, definitely we've done a lot of work making the transition from Privacy Shield, the previous framework, to the EU-US Data Privacy Framework, which we stood up. I would say actually, I know the biggest challenge we faced to date has been we've had to make a lot of IT infrastructure changes and updates in order to facilitate that transition. But also we've been working with companies to enable them to transition their commitments from the Privacy Shield to the Data Privacy Framework. And now we have around 2,700 companies who are currently participating in the framework. And it really is I think Bojana really put a finger on it where you say it's about interoperability and building bridges. And that's what we really have tried to do with the Data Privacy Framework is bridging the different systems in the European Union and the United States and ensuring that there are consistent privacy protections, but within those different systems. Mm-hmm. And that's something else we were trying to do more globally as well with the Global Cross-Border Privacy Rules Forum.
And as you look toward the one-year review, are there ways that you're thinking about tweaking or changing the framework? How do you kind of think about what the path forward is?
I don't think we're ready right now to make substantive changes to the framework. We did make some tweaks to the framework and the transition from Privacy Shield to the Data Privacy Framework. Mm-hmm. For instance, now key-coded data is covered under the Data Privacy Framework, which really adds a significant benefit for companies in the life sciences and medical sphere. But I think we'll actually have a good discussion with the Commission about how things have been operating in practice, about how we have stood up the framework, how we're standing up the redress mechanism, and really have a stock taking. But we'll have to get additional feedback, I think, from stakeholders, from the Commission and others about how things have been functioning. But I think it's a little bit too early right now to talk about making substantive changes.
And then the last thing I wanted to ask you about this specifically is just legal challenges. Are you confident that you can overcome legal challenges associated with the framework?
Yeah, no, we and the European Commission, we really focused our negotiations on addressing directly the concerns that were raised in the Schrems II decision that struck down Privacy Shield. Mm-hmm. And we're very confident that what the deal that we have struck here and the commitments the United States made under the Data Privacy Framework and the executive order meet the standards laid out by the European Court of Justice and can withstand future legal challenges.
Mm-hmm. And Bojana, I want to come back to you and just ask
he seems to be
what you think the biggest challenge is that companies face in navigating this patchwork of different data privacy rules.
Absolutely. Look, first of all, the more patchwork of the rules you have, the bigger and larger cost of compliance, we have. And so, I kind of ask ourselves, if we really believe in privacy and effective privacy and protection for people in a way that also enables responsible use of data, what do you want companies to do? Do you want them to spend very limited resources, because resources are not unlimited, right? On papering data flows, for example, having again to deal with the challenge to data protection framework, as Alex has said, or do you want them to actually do something like privacy by design, or data protection impact assessment, or developing responsible AI? See, that's really what companies want to do. They actually want to do the right thing. They want to do the accountability. But by having different rules, we are pushing them to do kind of administrative compliance burden, right? So that's the first point. I think the second point is, and particularly on data flows, right? So because, data is being restricted, and that means perhaps hindering privacy. And so, we need the same ways of thinking about that. I was yesterday chairing an interesting session on cloud computing, and cloud computing providers are saying, well, actually, if you want us to deliver private and secure cloud, you have to enable us to collect the news data, metadata, service data, to deliver that intelligence threat, cybersecurity, seamlessly and reliably across the world. Mm-hmm. And I think thirdly as well, there are really, it's not just about privacy. I think Aaron has said it just now. We've got AI rules that are keeping, they're burgeoning. We have got rules on online safety, on children's protection as well, on competition, content moderation. So all of these digital rules are intersecting with data protection rules. And it really becomes a very complex body of law globally to comply with. And, technology is just like us, right? We don't know borders. People use technology seamlessly, services and products. It's really difficult to actually design technology and to implement rules and tools based on a particular geography. And Morgan, I must say that because I know there's a big US audience there. I mean, the fact that we are seeing fragmentation in the US market as well, in terms of the US state privacy laws and US AI laws and proposals, I mean, that's not good either, right? We in Europe always envied US for having seamless rules for the whole country. This was what was behind the GDPR, to have more harmonized rules. We haven't quite achieved that. And now we are looking at US also going through a patchwork trend as well. And I don't think that's really good for compliance. It's not good for privacy. It's not good for people either.
Alex, do you have a reaction to that? Just her comments about patchwork in the US?
No, I think that definitely, I think they're definitely sort of adding additional sort of disparities between sort of different rules. I mean, it increases compliance costs and makes it harder for companies to apply these. I mean, internationally, we're trying to sort of bridge these gaps and sort of enable companies to comply, and that's sort of why the data privacy framework was so important, that it enables companies to comply with sort of EU law. But certainly, I mean, when you look beyond the EU, there's even more sort of legal requirements, and trying to sort of navigate all of that is complicated and expensive. And with the data privacy framework, we're trying to help particularly small and medium enterprises comply with that, because the smallest companies, they can go international, and that can be a real driver of growth for them, but they really don't have sort of the money for expensive compliance. And so that's why data privacy framework is so important, because it's affordable and an approachable means for companies to comply with their obligations.
And Bojana, is there one country that has the sort of the most difficult rules to comply with, and who has the best?
Okay, well, look, this really is not a beauty contest. I would really, even though we often try to do that, I would really say that we are looking for maybe three things as a successful future-proof privacy rules, but really also digital rules. One is, we need rules which are principle-based, outcomes-based, not too prescriptive. We determine the outcome, but let companies get there, and that they are risk-based. And what I mean, you focus your rules on the riskier uses of data. It's not data that we are regulating. It's not AI that we are regulating. We are regulating use of AI, and we have to have this gradation of the risk. And secondly, we need accountability, organizational accountability. We need companies to step up and demonstrate that they're corporate digital citizens. In fact, data protection framework that Alex talked about, is in fact a accountability framework because it requires you to have a privacy management program through which you implement policies, procedures, controls. You're calibrating these principle-based rules based on risk so that they deliver effective compliance. We at CIPL have been huge promoters of accountability, and we want to see companies in their boards truly implementing and being able to demonstrate that. And that's what the laws should show. And then finally, we need smart regulators. So regulators who are using new innovative techniques, who are also risk-based, who are strategic, and things like sandboxes, policy prototyping, digital hubs, fast lane services for SMEs in particular. Those are really the digital regulators. So look, so that's really what we are looking in laws. And so there are good things in GDPR. There are good things in other laws like Brazil and Singapore, Canada. Canada has got interesting way of thinking about fairness and proportionality. Singapore has got interesting way of implementing certifications. GDPR, excellent way of thinking about legitimate interest processing as opposed to just based on consent. And I would also add UK. Please look at what UK is doing. UK is trying to evolve its rules beyond GDPR, so GDPR 2.0, to, for example, take away some of that nasty consent fatigue, right? To take away some of the restraints around automated decision-making and enable AI, but give people rights in respect of that AI. UK is also trying to unlock the potential of data in research and development, so that there are some exemptions from some of the data protection principles. And that's really what we are looking. We are looking for these progressive legislative techniques, which are still maintaining privacy protection, but enabling also these rules to evolve and to be fit for the new wave of technologies like AI, like quantum, like biotech as well.
Alex, I wanted to ask you about some breaking news this week, which was that President Biden signed an executive order that restricts the sale by data brokers of certain sensitive data to foreign adversaries. Do you see that does that impact your work at all, and if so, in what way?
It doesn't impact my work directly. I think it's sort of, I have to refer questions about sort of the specifics of the executive order to the White House. But I mean, it's tangentially related, but I mean, it's much sort of a different issue that it's focused on. I mean, this is sort of on transfers of bulk data to sort of adversary countries. And so it isn't sort of isn't equivalent to sort of a commercial privacy legislation or a restriction on sort of data transfers and data flows. I mean, the United States and this administration remains committed to the principles of data free flow with trust and sort of promoting the free flow of data. And this isn't sort of like a data localization. It's sort of narrowly targeted at sort of a security concern. And yeah, the administration remains committed to sort of protecting the security and privacy of citizens.
Mm-hmm. And when it comes to congressional action on some sort of privacy legislation, how important is that to the administration?
I think it's sort of an ongoing priority for the administration. We definitely sort of have on a number of occasions, I think in the past couple of State of the Union addresses, the president has noted the importance of commercial privacy legislation, and it's something I think that there is an ongoing demand for, and we're definitely seeing sort of the expectations is increasing for privacy, and I think it's an important priority that we look forward to working on.
Mm-hmm. And I want to just close by asking both of you, there's plenty of congressional gridlock in Washington. These things are difficult to get done. What do you think the odds are that Congress actually acts on some kind of digital privacy legislation?
I can't really make a guess, but I mean, I hope that they do.
Bojana, what do you think?
Oh, look, I'm rubbish at placing bets, but all I can tell you, we do need federal privacy rules, because we need these rules also in relation to AI, right? There is this gap. There's big discussion. How do we regulate AI? Well, you know what? We can't jump the hoop unless we've got some basic privacy rules, because what we're going to find out that some of these rules are going to actually deal with quite a number of risks and concerns around AI. And then it's all about really targeted, laser precise congressional or federal or governmental action as well. So I do hope we end up with federal privacy rules. I think it will help overall what Alex talks about, which is data-free flows of trust. You know, we need this baseline of privacy to increase that trust and accountability. The US has done incredible steps in terms of pushing cross-border privacy rules, and that again is something that US companies comply with. So, you know, you ask yourself, actually, if they're complying with CBPR, if they're complying with data protection frameworks, well, really, you know, it would not be that much more difficult to comply with federal privacy law, particularly given what we are seeing in the countries. I think it really would help stabilize this kind of privacy agenda globally, and make us really realize that data is an essential asset to every country, to all people, and it enables more democratic, more just, more equitable, more fair world. But we do need to enable these data flows. You know, data is not oil, data is like environmental protection. And that's really what I would like us to see kind of more around the world, to raise the level, but also enable the innovation through accountable data flows.
Alex, Bojana, thank you so much for the conversation. I'm sorry our other guest dropped off, but it was still great. Really appreciate it, and for everyone coming in and watching.
Thanks for having us.